My background is actually a copyright lawyer and also a civil lawyer in a sense of contracting, and also as my law firm, which local ones probably know as Glickman and Partners. Glickman is Leon Glickman and Alexander Glickman is famous litigators in Estonia, so we do a lot of litigation work. So then also my side from there, from the IP side. And I have done my degrees here in Tartu University and University of Amsterdam in Information Law Institute. So where to start? Actually, first, when I start, I want you to kind of get rid of your sitting there and trying to respond me a little bit, because I understand that everybody's after lunch a bit this kind of fuzzy here. So how many of you are representing really a startup? Okay. How many of you have defined which objects, which objects in your products or services which are you developing, which IPR applies to these objects? Okay, 3. How many of you have some confidentiality rules in your startup? A little bit more. Okay, good. Now here we start. First, my question is that before we go in a strategy, I think it's really difficult to start on a strategy if you don't know what you have. It's really difficult to think about that, where I will go. Will I have a full patent strategy or will I have only a licensing strategy? If you don't really know what you have, how you decide? Where do you turn to? Do you turn to the patent attorney? Patent attorney will tell you, okay, I will file what you want. But this is not the question. So you need to define what you have, actually. So first question for me is always that, what do you have? Show me, what do you have? Then we can see. I can help you to maybe define what you really have. So do you have their copyrights? Do you have their database rights? Do you have their industrial design protection elements? Do you have their trademark, potentially, if you create it? Do you have their patent possibility? Do you have the utility model, which is like a small patent? So, okay. We are not going deep there today, or you have just simply business secret, which you mostly have, everybody. If you have defined this, what are the IPR objects, which IPRs actually apply to your objects, then you can go and see what is next. Next question always to ask that, okay, I have this object, I did it somehow, did I do it myself, fully myself, or sitting in a garage and doing something, and I know that I did it all by myself, with my own little hands, or did I use some outside contractors, or did I have some employees involved during this whole process, or I was actually working in some company, doing everything there, and suddenly I gathered a lot of information, and I decided that, wow, I want to have my own business. And I just took part of this information and went and did something maybe extra, and now I have my own product. So all these little different relationships there actually kind of influence, do you have all these rights? Because who can actually do something? This is a person. No company will not have initially rights. Creators are always these people in this auditorium. You are the creators, not the company. So the question is how the company will actually get these rights. These people here have to give it to them. So this is the question. This is already a contractual question. So who have the rights initially? Founders, of course, you as the founders, maybe former employer. Have you thought about it? Have you really read your, for example, agreement with your former employer and understood that actually not this person there is not the owner of everything? So is it maybe cooperation partner? You started in a garage with 2 of you. You did something, and then suddenly you had a huge argument, and one of you left. But you didn't agree on anything. In copyright terms, you have actually co-created. You are the co-owners. And the co-ownership, at least in Estonian law, I don't know many all other laws, but in Estonian law, co-ownership of the IP doesn't just terminate. You cannot terminate it. You have to terminate it like agreeing on that. It just doesn't terminate like such, like one left and suddenly you are the owner of everything. No, it doesn't happen like that. So maybe it's a client. Can a client be an owner of your stuff? I mean, if you had this kind of contractual relationship with somebody ordering you to do something and you didn't really pay attention of these terms which you signed, you just wanted to do it done, you just wanted to do it and that's it, and maybe you already assigned everything to this particular one client and you don't have anymore anything. So this is a question. Here comes all sorts of, well, in legal terms, non-compete confidentiality, unfair business practices, these kind of instruments which might kind of threaten you. So who else created there? Employees of the company. You have employees in your company. They are creating something. Does it always mean that all the rights belong to the company? I'm asking you, does it always mean that all the rights of what employees have created, does it all automatically belong to the company? Well, it depends on a contract, but it also depends on an object. In a sense that, for example, in Estonian law, copyright assigns, automatically. If the product is created during the direct, employment relationship, then copyright assigns. But it's not like that with a patent or a utility model. These rights are not going automatically to the company. I mean, the filing right doesn't go automatically to the company pursuant to the Estonian law. You have to get this right from your employee. This is, probably a bizarre thing. We are actually going to check it in this codification team, does it actually make sense that we have so protective regulations in the sense of employees? That do they actually initially need to have all these rights and actually like a blocking opportunity? But it's going to be a discussion there in this group. Okay, independent contractual partners. You're using some cooperation partners. So who will have the rights? They are doing for you something, they're doing some bits and pieces, but who will have all these monetary rights if we talk about copyright? On the basis of Estonian law, you cannot really say for sure that all these rights will be assigned automatically to the person ordering the works. It's not like that. Actually, we can say on the basis of Estonian law that both sides keep the rights. So both of them can actually use them later on. So is it something that you really want if you're a startup and you really want to create your own product, yeah? Okay, and then existing rights of the third parties. This is this thing that there might be somewhere out there somebody with existing rights. So maybe it is worth of checking that. And also, of course, already more details, open software. Maybe I have to make everything public. There is specific licensing terms, and this might be also a place where to look into. So do I have a plan how to use IPR? If you already have understood what you have, which is your product, which is your this kind of different intellectual property rights applying, and you have also understood kind of that did I get everything which I needed from all these little partners which I had during all this process, then you can start thinking what really to do with all this stuff which you have now in your pocket. Okay, how to use? What should I give away? How much secrecy or publicity and sale of expertise? So this is actually the question already, a patenting strategy or a confidentiality strategy. We know that they can kind of support each other, but they are not really these kind of things that they can coexist really fundamentally at the same time. Confidentiality and patenting, they have a different this kind of agenda. And then you need to decide what they can license. What you really have to license. If you are, again, for example, further developing something, how much how much will you license in the end? And how much you need to also license in with your inbound licensing? If you're using some technology created by the third parties, what should be these license terms in a sense that you don't restrict yourself too much. Maybe you need it for this project, but later on you develop that, actually I would need to use it little in a wider scope. And then actually this licensing terms doesn't even anymore cover it. So you need to renegotiate. So you a little bit need to think ahead where you are going to go. So if you're using this inbound licensing, which means that you are using third-party technology, then you have to think further than just this moment to getting it done. So this is the, can I develop my products further, yeah. And which is really the core elements that I should keep as a crown jewels. This is really the thing in the end that to think that will I patent, will I not patent? I mean, this is actually the question of the product which you have. There is no like one size fits for all. We cannot say here in panel that, I don't know, everybody go to patenting. It's just not right. You really need to think which is your product, which is your really this element in your product that makes your product this really successful thing. And then on the basis of that, you can already think which kind of IPR protection fits you. I mean, is it really the technology? Is it really this technological invention there? Then it's the patenting thing, yeah. But I mean, maybe it's a design element, it's completely design. And then there is, well, we don't discuss about patent anymore. We discuss, yeah, about the European design protection, for example. Okay. And of course, lastly, can I enforce my IP rights? Of course, if you want to have all these IP rights, you need to be sure that you are able to enforce them. Enforcing means also sometimes litigations, yeah? So you need to be sure that you are willing to take this risk that you need to litigate in the end. I mean, going and filing to a patent doesn't really mean that you are on a safe side. The patent filing means that during the patent filing process and even after the patent is issued, somebody can come and challenge your patent. So you have to be just ready to litigate. If you're not ready, I mean, what's the point of wasting all this money and energy and for what? I don't know. Maybe I'm not now talking not like a lawyer, but I mean, you have to be ready for that. There is extra cost involved. So minimum program, what I was thinking. As I said, you cannot say that one size fits for all, but to think about a trademark, yeah. I mean, trademark is something that simply identifies your product from all other products on the market. So if you want to be that your child will be known as your child, then go and pick a good trademark, but not this kind of one which is like descriptive or generic or I don't know, for the, I don't know, some waxing thing, a good wax is not a good trademark. I mean, it doesn't say anything, it's not identifiable. I mean, trademark, yeah, you identify your product, especially when it's a consumer good, you need to identify it. Then copyright, this exists from the day one. You don't need to do anything. You just need to be sure, have you obtained your rights. Confidentiality rules in your company, and some licensing strategy, what to license in and what to license out. This is my opinion to you. Thank you.
Thank you, Silja.